Hello friends, welcome back to my YouTube channel, that is Discourse on Law and Politics. So in today's video, we are going to cover 100 MCQs from the IPC here. And these questions are very important for the UP Judiciary as well if you are preparing for the Judiciary. If you are preparing for the Chhattisgarh, it is also important for Rajasthan, for Bihar, for Haryana, for Punjab. So whatever states you are having for the competitive examination, whether it is of the south, north, east, west, of any state of the India, for that this video is very helpful because we are going to cover the 100 MCQs here from the Indian Penal Code. Okay, so let's start. So before beginning this video, I request to all of you again, please subscribe my channel so that you can have more videos in future like this. So with this note, let's start the video here. The first question which you all can see here, this is here: the fundamental principle of criminal liability is embodied in the maxim actus non facit reum nisi mens rea. And the maxim which is here, which I am going to highlight here, you can see actus non facit reum nisi mens rea. So this maxim which is here of the IPC, it was developed by which courts? Okay, and the option which are given: equity courts, common law courts, Sadar Nijamat court, or none of the above. So this maxim has been developed by the common law court. So it is a common law doctrine. To that you can find it. So right answer of this is B. Now the next question is here: wrongful gain means. What is the meaning of wrongful gain? The first one is gain by lawful means of property which the person gaining is not entitled. Gain by unlawful means of property which the person gaining is not entitled. Third, gain by unlawful means of property which the person gaining is entitled. And D, all of the above. So the right answer of this question is here. If you just see this one, gain by unlawful means of property which the person gaining is not entitled. Next question, it is from the wrongful loss. You all can see here. So what is it? A loss by unlawful means of property which the person losing it is legally entitled. Loss by the lawful means of property which the person losing it is not legally entitled. And loss by lawful means of property which the person losing is not legally entitled. So you know that the loss is there, but it must be by the unlawful means. That means for this definition you will find that whenever the wrongful gain is happening the loss is there, you will find that in the wrongful gain the person is not entitled and he is doing by the unlawful means, while in case of loss he is legally entitled but the loss is happening towards the unlawful means. Next question: the provision of the personation at election under section 171D of the IPC. Now this question is with respect to the personation of the election at election, and the options which are given here: shall apply to a person who has been authorized to vote as a proxy for an elector under any law in force. Shall not apply to a person who has been authorized to vote as a proxy for an elector under any law in force. Does not lead any restriction under any law in force. And D, none of the above. The right answer of this question is here B. That means shall not apply. This is the right answer. I am highlighting this one. Shall not apply to a person who has been authorized to vote as a proxy for an elector under any law in force. Next question: dishonestly has been defined as doing anything with intention to cause wrongful gain to one person and wrongful loss to another person under which section of the IPC? The right answer of this question is here. The right answer of this question is the section 24. Okay, this is the correct answer. Moving to the next question: fraudulently. This is another definition from the IPC. Fraudulently has been defined as doing anything with intent to defraud. Under which section of the IPC it has been defined? and the fraudulently has been defined under the section 25. Therefore, the right answer of this question is the B. So my dear friends, if you are preparing for Chhattisgarh examination, prelims examination, then please try to see that whether you are eligible, you are able to solve the question, and you can check about your preparation for the Chhattisgarh Judiciary. Now next question, when a criminal act is done by several persons in furtherance of the common intention of all, then what will happen? Each of such person is liable for the act in the same manner as if it were done by him alone. So when any action has been done and the action is like the criminal act and it is in furtherance of common intention, whether in that case all the person will be liable for the act in the same manner or in the same way. So yes, this is right option. A is the correct answer, because every person will be equally liable. So it is a question about the common intention you can find from there. Now the next question is here, which among these codes is included in the schedule to the Prevention of Money Laundering Act? So which of among these code is a part of the Prevention of Money Laundering Act of 2002? So we are solving this here from the IPC. So definitely the IPC is the answer here. Now next question, to establish section 34, that means common intention under the IPC. Common intention be proved but not overt act to be proved. Common intention and overt act both be proved. Common intention need not be proved but overt act be proved. And D, all of the above. So the right answer of this question is here. That is the common intention to be proved but not overt act be proved. Only merely having the common intention is sufficient to put a person in liable for the liability. So this is how you can find that. Next question is here, section 34, and this is a very famous question from the section 34. Section 34 of the IPC. Section 34 of the IPC creates a substantive offense. Is a rule of evidence. C, both A and B. So what you find that this section 34 is going to be used when the many people are working for the common intention. Therefore, it is to be as a part of the rule of evidence. Okay, moving to the next question. X and Y go to murder Z. X stood on guard with a spear in hand but did not hit Z at all. So in this case, both would be equally liable. So X and Y both are liable for the murder of Z. Moving to the next question here. The next question is here, you can see voluntarily has been defined as an effect caused by means whereby a person is intended to cause it or by means at the time of employing those means known or had reason to believe to be likely to cause it under. So under which section of the IPC it has been defined voluntarily? So voluntarily has been defined under section 39. So the definition is section 39 and therefore the answer is A. Under section 45 of the IPC, life denotes. What is the meaning of the life here? Under the section 45 of the IPC. And the options which are given here, you all can see life of human being, life of an animal, life of human being and an animal both, or life of either human being or animal. So because the IPC talks about the criminal actions of the human being, so of course this section 45 will always talk about the life of the human being. So the right answer of this question is A. Next question, under section 46 of the IPC, death denotes. So of course, as in the section 45, the death means life means human being, life of human being. Similarly, the death of the human being is going to be there, because this IPC governs the actions of the human being. Okay. Next question, illegal signifies everything which is an offense, everything which is prohibited by law, everything which furnishes ground for civil action, and D, the last option is the all of the above. So my dear friend, this is a question which had been asked in various judicial exams, and the answer is it will cover the all of the above. So that means it will cover all these actions here. Moving to the next one, animal denotes any living creature including human being, any living creature other than human beings, and then this one. So of course human being is not a part, so therefore B is the correct answer. How many types of punishment have been prescribed under the IPC? So how many types of the punishment is given? So my dear friends, you all know that the right answer of this question is 5. their total number of the punishment is the 5 year. Okay. Next question. Under section 60 of the IPC, in certain cases of imprisonment, the sentence of imprisonment has to be wholly rigorous, has to be wholly simple, can be partly rigorous and partly simple. So the right answer of this question is here, that is it can be partly rigorous as well as partly simple as well. So right answer is the C here, which is the right answer. So C is the correct answer. Next question. Sentence of imprisonment for non-payment of fine under section 64 of the IPC. So in case someone who is not able to pay the amount of fine, then what will be the sentence of imprisonment, number of years or months. Okay, now my dear friend, this is a question very important. It had been asked in the so many states also. The options which are given is shall be in excess of any other imprisonment to which an offender has been sentenced, shall be concurrent of any other imprisonment, shall not be in excess of any other imprisonment, and B, both and B and C. So the right answer of this question is here, that is the A. Okay, so the A is the correct answer. Shall be in excess of any other imprisonment to which an offender has been sentenced. So in case he could not pay the amount of fine, then he will be liable for this. Under section 65 of the IPC, sentence of imprisonment for non-payment of fine shall be limited to. So what do you find that here? This is a very important question. Okay, and remember that it is a very important question here. So I am just writing very important here with this question number 20. Under section 65 of the IPC, sentence of imprisonment for non-payment of fine shall be limited to 1/3 of the maximum term of imprisonment fixed for that offence, 1/4 of the maximum term of imprisonment fixed for the offence, 1/2 of the maximum term of the imprisonment fixed for the offence, equal to the maximum term of the imprisonment fixed for the offence. So the right answer of this question is he is going to be liable for the 1/4. Okay, so the right answer of this question is, which I am going to highlight, just see, this is the B. B is the correct answer. He will be liable for the 1/4. Okay, in case of an offence punishable with fine only, imprisonment for non-payment of fine. This is also very important question. I am writing VI, very important. The non-payment of the fine has to be rigorous, has to be simple, can be rigorous or simple, can be partly rigorous and partly simple. Now in this case what happened, where the offence is punishable only with the fine, but the offender could not pay, was not able to pay the fine, then in that case what kind of the imprisonment will be there? So in that case it is to be the simple one. Okay, so the B is the correct answer. Under section 490A of the IPC, cruelty includes. So what is the meaning of the cruelty under section 490A of the IPC? The first one is harassment of the women, physical cruelty only, mental cruelty only, cruelty by the wife. So the right answer of this question is here A. That means harassment of the women. So this is the right answer. Okay, I am highlighting this. Under section 490A of the IPC, cruelty includes harassment of the women. Next question. In case of an offence punishable with the fine only, an offender who is sentenced to pay a fine of not exceeding ₹100 but exceeding ₹500, the imprisonment in default of payment of fine shall not exceed. So where you find that a offender is sentenced to pay a fine of not exceeding ₹100, less than ₹100, but more than ₹50, then in that case what kind of the imprisonment would be there in case of the default of the payment? So the right answer of this question is he is going to be liable for here the 4th month. So this is the right answer. Okay, next question. In case of an offence punishable with fine only, an offender who is sentenced to pay a fine exceeding ₹100, the imprisonment in default of payment fine shall not exceed. यानी कि अब 100 रुपये से ज़्यादा का अमाउंट हो गया है और उसको वो पे नहीं कर पाता है, तब उसकी कितनी इम्प्रिजनमेंट होगा? द आंसर इज 6 months. Next question. Section 64 of the IPC provides for the options which are given: nature and maximum limit of imprisonment for non-payment of fine. The next option is here: nature and minimum limit of imprisonment for non-payment of the fine. Nature but does not prescribe any limit of imprisonment for non-payment of fine. limits of imprisonment for non-payment of fine but does not prescribe the nature of the imprisonment. So what you find that this section which was in question here, it only talks about the nature but does not prescribe any limit of imprisonment for non-payment of the fine. Okay. The next question again from that one, imprisonment for non-payment of fine shall terminate. So in case who could not pay the fine, not fee, then in that case it will terminate. When it will terminate? So the options which are given here, you can see on payment of fine, on expiry of term of imprisonment for non-payment. In both the situation it can terminate. If you pay the fine earlier before the end of the imprisonment, then in that case also you will be allowed to go outside the jail. So this is how you can find. Next question, in case of imprisonment for non-payment of fine, if a part of the fine is paid, such sentence. So if you find that there is a non-payment of fine, but a part of the fine has been paid. So in that case, what will happen? Shall be reduced proportionately, shall not be reduced in direct proportion to the fine paid, shall be reduced but subject to the direct discretion of the court as to the quantum of reduction, and D, all of the above. So the right answer here, we find that the right answer of this question is here. You all can see, which I am going to highlight here. This shall be reduced proportionality. So to what much amount he could not pay, to that extent he will be imprisoned. Okay. Next question is from section 73 of the IPC, and it is also very important section. Okay. So section 73 of the IPC provides for the maximum limit of solitary confinement to be, and this is very important question, and this question had been asked in various competitive examination. So the answer of this one, the maximum limit of solitary confinement यानी एकांत जो बोलते हैं जेल में रखने का, the maximum term is 3 months. Okay. Next question, if an offender has been sentenced to imprisonment not exceeding 6 months, the solitary confinement. So if an offender has been sentenced to imprisonment not exceeding 6 months, the solitary confinement would be, the options which are given here, shall not exceed 15 days, shall not exceed 1 month, shall not exceed 2 months, and shall not exceed 45 days. And the right answer of this question is here, that is the B. Okay, that means shall not exceed 1 month. So this is the right answer. Next question, if an offender is sentenced to imprisonment for a term exceeding 6 months but not exceeding 1 month, the term of solitary confinement will be, the options which are given, shall not exceed 1 month, shall not exceed 45 days, shall not exceed 2 months, and shall not exceed 3 months. So the right answer of this question is here, that is the C. Okay. The next question, if an offender is sentenced to imprisonment for a term exceeding 1 year, the term of solitary confinement shall not exceed, यानी किसी को 1 साल से ज़्यादा का सज़ा मिल गया है, तब solitary confinement का टाइम कितना होगा. And the options which are given here, you can see 1 month, 2 months, and 3 months, and this, the last option, that is the 6 months. And the right answer of this one, the 3 months. So the right answer of this question is here, which I am going to highlight here, that is the 3 months. Moving to the next question here. Nothing is said to be done or believed to be done in good faith, which is done or believed with due care and intention, is the definition of good faith contained under which section of the IPC? So the good faith has been defined under section 52 of the IPC. So therefore the right answer of this question is C. Okay, so I am just highlighting the C, and there you can find here. Next question. Next question, general exception are contained in which chapter of the IPC? And the options which are given here, you can see chapter 3, chapter 4, chapter 5, and chapter 6. And the right answer of this question, you know that very popular question is this, it is in the chapter 4 of the IPC. So this is the right answer. Next question, section 76 provides that nothing is an offense which is done by a person who is, or by reason of mistake of fact in good faith believes himself to be bound by the law to do it. Mistake of law in good faith believes himself to be bound by law to do it. Mistake of fact believes himself to be bound by morals to do it. And D, all of the above. So right answer of this question is here, mistake of fact, which I am going to highlight here, The right answer of this here, mistake of fact in good faith believes himself to be bound by law to do it. Next question, which is based on the section 79 of the IPC. Nothing is an offence which is done by a person who is justified by law or who by reason of mistake of fact in good faith believes himself to be. And options which are given: bound by law to do it, justified by law to do it, bound by morality to do it, and D, all of the above. So the right answer here is that is justified by the law. So this is the correct answer. So a person would not be liable if he believes that he is justified by the law to do it. The next question here, maximum, it is not maximum, it should be the maxim. Ignorantia juris non exequat. What is the meaning of this maxim? Maxim, that is the ignorantia juris non exequat. And the right answer of this one, the ignorance of law is no excuse. So this is the right answer of this question. This question is also very important, so therefore I am writing a VI, because this maxim had been asked so many times in various competitive examination of judiciary. Now next question is here, section 76 and 79 of the IPC provides general exception of the mistake of law and mistake of fact. The B option, mistake of fact, both mistake of law and mistake of fact, either mistake of law or mistake of fact. And the right answer here, which you can find, that it is about the mistake of fact, because ignorance of the law is no excuse. So it is about the mistake of facts. Okay. Next question, accident as an exception has been dealt under which section of the IPC? So you can find here there are so many sections which are given, and the right answer is section 80 of the IPC, where you will find that the Stephen versus Deadly wala case, if you remember that. Okay. Next question is here. The next question is here, under section 80 of the exception of accident is available when an offence is committed while doing a lawful act in a lawful manner by lawful means, doing a lawful act in manner by any means, doing a lawful act in lawful manner by any means, or all of the above. So when the exception is going to be as a difference there, so option which is given here, it is to be an action which is to be done by the lawful act in a lawful manner by the lawful means. Then in that case, you are eligible to get the difference of the accident here. The next question which is here, the principle as to the way in which a man should behave when he has to make a choice between two evils is illustrated. Now it is a case which is based on the necessity. Okay, it is a point which is based on the necessity here. So you can see here. Now the options which are given, section 80, 81, 82 and 78. And the right answer of this question is section 81. This is the correct answer. So this was based on the, this is section 81 of the IPC, which is based on the necessity. So the right answer is this one I am highlighting here. So it is a case of the necessity here. Okay. Next question, the motive under section 81 of the IPC is prevention of harm to person, prevention of harm to property, both A and B, either A or B. So what you find that, my dear friends, in this case it may be both, either A or B. इसमें से कुछ भी हो सकता है, and based on that you can have a right of necessity. Okay. Next question is here about the infancy. Infancy as an exception has been provided under this section of the IPC. So it is about the child who is below the 7 years. So it is below the age of the 7 years. For that this section is going to apply. And the options which are given 80, 81, 82 and 84. And the right answer is here 82. So this is the correct answer. Okay. Moving to the next question here. Section 82 of the IPC provides that nothing is an offence which is done by a child under the age of the 7 years of age. So this is the correct answer. Next question is also from section 82 of the IPC, so that you can get more questions and more idea about this one. It is about the presumption of fact, a rebuttable presumption of law, a conclusive or rebuttable presumption of law, and none of the above. So what you find, my dear friends, once a child who is below the age of 7 years, it would be a conclusive proof that he has no intention to commit the crime. So therefore it is going to be the irrebuttable, and also it is going to be the conclusive proof. So this is how you can find this. This is the right option. Next question is here. A person is stated to be partially in capex under section 83 of the IPC, if he is aged above 7 years and under 12 years, so this is the right answer. This is about the section 83 of the IPC, where a child who is above the 7 years but below the 12 years, then in that case he can be liable for his action. Moving to the next question here, section 83 of the IPC lays down whether it is a presumption of fact. The next is an inconclusive or rebuttable presumption of law. Yes, this is the right answer, because even a child who is above the 7 and below the 12 years, he has to prove that he is not in a position to understand the nature of the act. So therefore it is a rebuttable one. Next question is section 82 of the IPC lays down that the rule of wholly in capex, partially in capex, both A and B, and last either A or B. So this is about section 82, where the age of the child is less than 7 years. So in this case, the right answer of this question would be the A. That means wholly in capex, he is not competent to do the action. So therefore this answer is going to be correct here. Next question, under section 82 and 83 of the IPC, an offence is punishable if it is done by a child. And the option which are given here of a below 7 years of age, of 7 years of age but below 12 years of age, if he has not attained sufficient maturity and understanding, of 7 years of age but below 12 years of having attained sufficient maturity and understanding, and D, all of the above. So what you find that it is this one, C here. It is about of above 7 years of age but below 12 years of age, having attained sufficient maturity and understanding. Okay. Next question is here. Which of the following pair is not correctly matched? So here the cases are given here. So you can find that the insanity, which is about the case McNaughton case, it is correctly matched. Mens rea is also matched. Intoxication is also matched, but this case is not correctly matched. This case is belonging to the intoxication. So therefore the right answer of this question is here, that is the B. This is also a question which had been asked. Okay. The next question is here, the actus non facit rea nisi mens sit rea. And what is the meaning of this maxim? The option which are given, crime has to be coupled with the guilty mind. There can be no crime without a guilty mind. Crime is the result of guilty mind. Crime mind leads to the crime. So the right answer of this question is here, that is the B. Okay. So the B is the correct answer. There can be no crime without a guilty mind. Okay. Next question. In every statute, mens rea is to be implied unless the contrary is shown. This is again a question which had been asked in UP Judiciary, and the answer is Seraz D. Rudgen. Okay. The next question is here, the physical aspect of a crime is actus reus. The mental aspect of crime is mens rea. The motive is the desire to commit crime. Which of the following is correct for the aforesaid? So we have to find which statement is correct and which is not correct. So let's start here one by one here. Here you can find that this is also correct. It is also correct. Yes, motive is the desire to commit crime. So therefore the right answer is the D here. Okay. The next question is here. Section 84 of the IPC provides for, okay, whether it is about medical insanity, legal insanity, moral insanity, unsoundness of mind of any kind. So it is dealing with the legal provision. Section 84 is about the legal provision, and therefore it is about the legal insanity. The next question is here, irresistible impulse is a defense of. Irresistible impulse is defense of, whether it is a defense in India, in England, or in India or England both. So where it is a defense, so it is not a defense either in India or England. So this is the correct answer. The next question is here, who hangs the prisoner in pursuant to the order of court is exempt from criminal liability by virtue of. So you know that this question had been asked in UP also and Bihar also. Okay. So the answer of this question is here 76, because he is doing as per the law here. Next question is here, insanity as a defense means that a person at the time of doing an act by reason of unsoundness of mind is incapable of knowing. So a person who is insane, he can take this defense that at the time of doing an act he was unsound of mind because of the reason that he was not capable to know the nature of the act, that what he is doing is wrong. C, that what he is doing is contrary to law. D, either A, B or C. So what is the right answer of this question? Please give your answer to comment box. If you are visiting this video, I hope that you are solving the questions here. The right answer is here, that is the D. He can defense of any one of them three. Next question is here, which of the following is correct? Okay, the question which is here, the burden of proof that the accused was not insane at the time of commission of offense is on the prosecution. Okay, this is the one statement. The burden of proving that the accused was insane at the time of commission of offense is on the accused. Okay, there is a rebuttable presumption of fact that accused was insane at the time of commission of offense. D, and the last option, it is a matter of inference to be drawn by the court on the facts proved by the prosecution. So my dear friend, this is the case which you find that whenever someone is taking the defense of no general exception, then the liability would be always on the accused person. Okay, so he has to prove, the accused has to prove this one, that he was having that kind of insanity, and due to that he was not in position to understand the act and the nature of the act here. Okay, next question is here, for unsoundness of mind, the impairment of the cognitive faculty of mind to escape criminal liability. So when you are using the word unsoundness of mind, when you are using the defense of unsoundness of mind, the cognitive faculty, that to take the decision about whether जो चेतना होती है, जो मानसिक चेतना होती है, that means to take the proper decision, it must be the cognitive faculty must be impaired, पूरी तरीके से खराब हो जाए, must be total, must be partial. C, both A and B, and D, the last option which is given here, that is the none of the above. So he will be able to take this defense when he will be able to prove that because of the unsoundness of mind, his cognitive faculty of mind was totally impaired. Next question is here, with respect to the intoxication as a defense is contained under which section of the IPC? And the right answer of this question is here, the intoxication has two sections, both 85 and 86 here. So the right answer of this question is here D. Okay, so D is the correct answer. Okay, next question is here, for a defense of intoxication to escape criminal liability, the degeneration of mental faculties must be total or must be partial, or C or B, both. So what you find that, dear my friends, it is with respect to the intoxication. So in this case, the accused person can take the defense that he has to prove that there is a total degeneration of mental faculty. So this is how you can find that. Then in that case, he will be able to take this defense which is given in the A. Okay. Next question is here, for a defense of intoxication to escape criminal liability, the intoxication can be self-administered. When someone is taking a defense of intoxication, at the time the criminal liability of the intoxication can be self-administered or administered against his will or knowledge, should not be self-administered, and D, all of the above. So the right answer of this question is here, that is the B, administered against his will or knowledge. So he must not aware about that and it was against his will. Then in that case he can take the defense of this. He can take the defense of this intoxication. Next question is here, in case where the act involves a specific mens rea, in case of intoxication under section 86 of the IPC, then the existence of mens rea is presumed, the specific mens rea is not presumed. C, the specific mens rea depend upon the attending circumstances and degree of intoxication, and D, none of the above. So whenever there would be a question about the intoxicant use, and then also there is a question about that under section 86, and in that case the action involves a specific mens rea, then it depends upon the mens rea upon attending circumstances and degree of intoxication. To that extent, how much he was incapable, how much he was having the mens rea, that depends upon the degree of intoxication. The next is voluntary non-fit injuria is contained. So now it is that you had given the consent, and therefore the whatever damage has happened to you, it is because of your consent. So under which section of the IPC it has been given? So it is in 87, 88 and 89. So all in this section you find that if you had given a consent, then in that case you will go with this doctrine of voluntary not fit injuria. Okay. The next question, which is also based on the consent, here you can see the defense of consent applies to private wrongs, public wrong, both A and B. So it applies to the private wrong only. Okay, it is not for the public wrong. The next question is here, the defense of consent is restrictive in its applicability in case involving, and the options which are given here, inalienable rights, that is B, alienable rights, or both A and B. So what you find that the defense of consent is restrictive in its applicability in case involving the inalienable rights. So this is the right answer here, inalienable rights. Okay, moving to the next. The next question is here, the defense of consent is not allowable in cases of, and the options which are given, the consent to cause death, consent to cause grievous hurt, both A and B. And the right answer of this question is here, that is the C. Okay, because it is not possible that you can give the consent for the causing the death as well as the to cause the grievous hurt. Next question, operation of consent to all offences short of causing death intentionally has been extended under which section of the IPC? And the options which are given here, section 88, section 90 of the IPC, and the right answer is just section 88 of the IPC. For this section, the offence short of causing death intentionally has been extended. Moving to the next question here. Under section 89, the consent in respect of infants under 12 years of age or person or under section 89, the consent in respect of infant under 12 years of age or person of unsound mind can be given by the guardian without any restriction, can be given by the guardian subject to restriction mutually agreed upon, can be given by the guardian subject to restriction imposed by law, and D, all of the above. So yes, the right answer of this question is here, that is the C here, can be given by the guardian subject to the restriction imposed by the law. So a child who is under the age of 12 years or a child who is or any person who is of unsound mind, for that person any guardian can give the consent on behalf of that person. Next question which is here, you can see the consent is not valid consent under section 90 of the IPC if given under a fear of injury or misconception of fact, if given by a person of unsound mind, if given by a child below 12 years. And the right answer is this, that is the D here, because in all these cases the consent would not be could not be considered as a valid consent. Next question is here, consent given under compulsion arising out of threat or injury, and the injury or threat is like that, excuse the causing of death, excuses causing of any offence against the state punishable with death, both A and B. So now here you can find that the consent has been given, but it was given under the compulsion. Okay, so for that whether it would be allowable, so it is not, neither A or not B. Okay, so both are not applicable. So this is the right answer. Moving to the next question, the maxim de minimis non curret lex. What is the meaning of this maxim? Okay, de minimis non curret lex. And the options which are given here, law would not take action on small and trifling matter. The next is law does not ignore any act which causes the slightest harm. The C is law would not take action in serious matter. And D, all of the above. The right answer of this question is here, that is the A. What says law would not take action on all small and trifling matters. So my dear friends, in UP Judiciary and also in Chhattisgarh, this was a question which had been asked. Okay, moving to the next question here. The next question is here, de minimis non curret lex is contained under which section of the IPC? And the options which are given here, you all can see 92, 93, 94, 95. And the right answer of this question is here, which you can find here, that is the section 95 of the IPC. The next question is coming from the private defense. Okay, The right of private defense is contained under which section of the IPC? And the right to private defense is contained under section 96 of the IPC. This is the correct answer. The next question is here, the right to private defense is based on the natural instinct of self-preservation, self-respect, and the third option is self-sufficiency and self-reliance. And the right answer of this question is here, that is the A, self-preservation. Okay, so this is the right answer. Moving to the next question, the right to private defense is unrestricted, subject to restriction contained in section 99 of the IPC, subject to restriction contained in chapter 4 of the IPC, subject to restriction contained in any other provision of the IPC. This is also important question, and this was a question which had been asked also in the UP Judiciary as well. So the right answer of this question is here, that is the B. Okay, so the right answer is here, that is the B, which I am going to highlight here, subject to the restriction contained in section 99 of the IPC. This is the correct answer. The next question is here, right to private defense is allowable under all circumstances, allowable where there is a limit, there is a time to have the recourse to the protection of public authorities, allowable where there is no time to have recourse to the protection of public authorities, and D, all of the above. So the right to private defense will happen only when you don't have any resource or no things where you can take the help from the public authorities. So the right answer of this question is going to be the C here. This is the right answer. Okay. Next question is here, the law on private defense in India. The options which are given is the same as in England, is narrower than one in England, is wider than the one in England, and the another option is none of the above. So the right to private defense which we are having in India, it is wider than one in England. So it is more wider than the England. The next question is here, the right to private defense is allowable with respect to what? Harm to body, harm to property, harm to animal property, all of the above. And the answer of this question is here, it is allowable against the all of the above. So this is the D is the correct answer. Next question is here, under section 98, right to private defense also is allowable against a person of unsound mind, a person who does not have maturity of understanding, both A and B, neither A nor B. So this right to private defense under section 98 is allowable against both the persons. So answer is C is correct. The next question which you all can see, every person has a right of private defense of his own body and the body of any other person against any offense affecting the human body has been provided under which section of the IPC? And yes, it is in the section 97 of the IPC. Okay, so where you can have a right to private defense about your body, also against the and the body of any other person. Okay, next question is here, every person has a right of private defense of his property or of any other person against certain offenses affecting the property has been provided. So this is with respect to right to property when he can have a private defense. And the options which are given here, this A is section 95 of the IPC. It is not the provision. Going to the next options, section 96, yes, it is also not there. The next option which is given here, section 97 of the IPC, yes, it is correct here. So moving to the next question, right of private defense is not allowable to the aggressor, to the person who is attacked, to the aggressor against an act done in private defense by the person attacked. Only A or C is the correct. So what you find that the right of private defense is not allowable against the aggressor if an act done in private defense by the person attacked. Okay, so this is not the right to private defense would be allowable there. The next question is here, in case of free fight between two parties, the right of private defense is allowable to both the parties. The next, the right of private defense is allowable to individuals against individual. No right of private defense is allowable to either party. Right to private defense is allowable only to the one party. So in this case, there is no right to private defense when there is a free fight. Okay, so C is the correct answer. The next question is here, under section 99, the right to private defense is not allowable at all against public servant engaged in the discharge of their lawful duties. Okay. Allowable under all circumstances against the public servants engaged in the discharge of their lawful duties. Available against public servant only when their acts cause reasonable apprehension of death or grievous hurt. So this is the C is the correct answer. Okay, C is the correct answer here. Moving to the next question. Right to private defense under section 99 of the IPC extends to cause more than harm is necessary for the purpose of defense, does not extend to causing more harm than is necessary for the purpose of defense, does not extend to causing the harm necessary for the purpose of defense, and restrict the harm caused to be less than the one necessary for the purpose of defense. And the right answer of this question is here, that is the B. Right to a private defense under section 99 does not extend to causing more harm than is necessary for the purpose of defense. So this is the right answer. Next question is here. Right of private defense extend to causing death under the circumstances laid down under which section of the IPC, and the options which are given here you can find as section 100 and 103. It extend to cause the death. You can cause death if you have the conditions which are given under section 100 and 103. Now let's see the next question is here. A right of private defense of the body extend to causing death has been dealt which section of the IPC. So as you had seen in the previous question, we found that section 100 of the IPC says that you can have a right to private defense to cause the death of someone's. The next question is here. Right of private defense of property extending to cause the death of has been dealt under which section of the IPC? The right answer of this question is it is in the section 103 of the IPC. You can cause someone's death if it is as per the conditions given in the section 103 of the IPC. Next question which you can see here, question number 89 here. In cases of assault causing reasonable apprehension of death or of grievous hurt, the right of private defense extend voluntarily. So when there is apprehension of death or grievous hurt, then in that case the right to private defense would extend to the cause the death. So when in that case there is apprehension of death, you can go to cause the death here. Next question. In case of assault with the intention of committing rape or of gratifying unnatural lust, the right of private defense extend voluntarily. So in that case the right to cause and right to have private defense will go to the including even death also. You can cause the death of some person if there is some kind of this situation happens. So this is how you can find here. Next question. In case of kidnapping and abduction, the right of private defense extends voluntarily causing. So in case of kidnapping or abduction, then in that case right to private defense will go to what extent? It will go to any harm including the death. You can cause the death also during the time of kidnapping or abductions. Okay. Next question which you all can see here, which we are having here. In case of robbery or dacoity, the right of private defense extends voluntarily causing, and the options which are given here, that is with respect to robbery or dacoity, the right to private defense in this case, the option is any harm including death, any harm other than death, any harm other than grievous hurt, both B and C. And the right answer of this question is here, that is the, so the question is asking that in case of robbery or dacoity take place, whether you can cause the death. Yes, you can cause the death. You can do any harm including including this death as well. So this is the right answer. Next question. Where a wrongdoer commits housebreaking by night, the right to private defense extend to voluntary causing. So someone who does a kind of a housebreaking in the night, so what kind of the the rights would be there? To that extent you can have private defense. So in that case you can also, the defense would be any harm including the death. So B is the correct option here. Moving to the next question here. Where a wrong leads to mischief by fire on a building, used a human dwelling or place for custody of property, the right of private defense extend voluntarily causing. So where a wrong leads to mischief by fire on a building used as a human dwelling or a place for custody of property, for custody of property, the right of private defense extend voluntarily causing this. And the answer of this case is also this, any harm including the death. Next question which you all can see here, under section 102 of the IPC, the right to private defense of the body commences as soon as the reasonable apprehension of danger to the body arises and continues as long as the apprehension continues. Okay, yes, this is the right answer. You can have the right to private defense of body once you have a reasonable suspicion that it is a danger to body, and it will continue so long you have that reasonable apprehension. Okay, moving to the next question is here. The next question is here, under section 105 of the IPC, the right of private defense of property in case of theft commences when a reasonable apprehension of danger to the property commences, and it will continues, the options which are given, and continues till the offender has effected his retreat with the property. The next option is continues till the assistance of the public authorities is obtained, continues till the property has been recovered, and D, all of the above. So in this case, under section 105 of the IPC, when right to private defense with respect to theft, in these cases it will be continued. So this is the right answer. It will continue and that till that. Okay, next question which you all can see, it is from section 106 of the IPC. It says the section 106 of IPC extend the right of private defense in case of apprehension of death to causing, and the options which are given here, any harm other than death to any innocent person, B, any harm other than grievous hurt to any innocent person, C, any harm including death to any person, innocent person, and D, none of the above. So in this case, under section 106 of the IPC, the right to private defense in case of apprehension of death, it will continue for causing any harm including death to any innocent person. So this is the right answer. Next question is here, chapter 5 of the IPC deals with the options which are given here. It is abatement attempt. So this chapter deals with the abatement. So this is the right answer. Okay, A is the correct answer of this question. Moving to the next question here. So before seeing the next question, I request to all of you, please subscribe my channel so that you can have such kind of the videos. Okay, let's start. Question number 99. The right of private defense is not eligible. When it is not eligible, the question is here which is given. The answer is options which are given here. Against any act which in itself is not an offense, against any act which is not legal wrong, against any act which is a moral wrong, and D, all of the above. And the right answer of this question is here. This is the answer is D. It is all of the above. So this is the right answer. Next and the last question of this one, and the rest question we will cover in the next series of this video. Section 97 of the IPC extend the right of private defense of property to the offense of cheating, misappropriation, theft or robbery, and the right of private defense for the offenses of theft and robbery. So with this I have finished this video here. I hope that you all have found as useful. In case if you want to improve it more, please give a suggestion. I invite suggestions. I invite more questions. So thank you to everyone for watching this video, and thank you very much again. Thank you.